we're going to wrap up Unit 6 by looking at civil rights, and we'll do this in two parts. First part, let's set some basic principles and guidelines. First off, in the concept of equality, we need to accept the fact that discrimination happens frequently in our society. We are not a discrimination-free democracy. You can't vote unless you reach the age of 18. You can't drive a car typically until you reach the age of 16. So that's age-based discrimination, and it's allowed because it's a reasonable classification. There's a very good justification for that discrimination, for that separation of people into different classifications. For a long time in our history, women could not serve on submarines in the military, and that was deemed a reasonable separation, reasonable classification with a purpose behind it. Now, what happens though is when you use race as a factor in creating a classification, since race is a suspect classification, it is applied with strict scrutiny. That's how the court will look at any race-based discrimination. They'll use strict scrutiny to determine what is the true purpose of this law, what is the intent of this law, and that is a very high standard that the courts hold, and very few things that are race-based get by in this country. Now, if we look at civil rights over the course of the history of our court system, when we start with the Dred Scott decision that established that African Americans at the time were not, in fact, citizens, so they were denied tremendous rights. Now, further hurting the cause of African Americans in this country was the court case of Plessy v. Ferguson, which established the idea that separate can be equal. So you could have separate but equal facilities. Now, the practicality of that was that separate facilities were in no way equal. So we get eventually to Brown v. Board, which was a class action lawsuit in Kansas. And the Supreme Court, in a landmark decision, said that separate facilities are inherently unequal, and they ordered the desegregation of all public schools in the United States. This was really the start of the civil rights movement. This action was in 1954, and it kick-started a rapid series of events that would span the next decade plus, where civil rights saw a tremendous movement in our country. Now, Congress gets in on the act. They passed the Civil Rights Act in 1964, and this ends racial discrimination in public accommodations. And the Congress used the Commerce Clause, arguing that the interstate commerce is affected when people are discriminated against and when certain segments of the population are denied access to facilities. This act also prohibits discrimination in employment and created the Equal Employment Opportunity Commission. Now, the Voting Rights Act in 1965 said that there were no literacy tests and that voter registration would be assisted in the states, that bilingual ballots would be made accessible, Justice Department officials could go in and inspect the registration procedures of any states that had a history of discrimination. So from Brown through Civil Rights Act, through Voting Rights Act, we saw an unraveling of the Jim Crow laws. Now, there's been some movements as of late as far as civil rights is concerned on the affirmative action front. The use of race as a factor to try to level the playing field for past injustices. And we see this predominantly in college admissions issues. There was the court case of UC Regents versus Bach, where Bach was a white student denied access to UC Davis's medical school. And the court found that the use of strict racial quotas in admissions to universities are not acceptable. Then fast forward to the late 1990s, early 2000s, there were dual cases, Gratz v. Bollinger and Grutter v. Bollinger. And Gratz was against the University of Michigan's undergraduate policy that awarded points to minority students. And the court said that the use of point system was unconstitutional. It violated equal protection. In the Grutter case, that was against the University of Michigan Law School. And the court found that race can be a factor in determining admissions to universities. So that wraps up civil rights, a brief overview of the history of struggles for African Americans in our country.